Hello, everyone. This is Tom Fox back again with Jonathan Armstrong for another episode of the award winning Life with GDPR. Welcome back, Jonathan.
Thanks very much, Tom. Happy New Year to everyone.
Jonathan, you informed me in the green room of an upcoming deadline that neither I nor many of my colleagues are probably aware of. I certainly wasn't. Of February 1. What happens February 1 that compliance officers and others need to be aware of?
Yeah, February 2 it is, but
Feb 2.
February 1's a good time to be prepared. So we've talked before about the EU AI Act, which at the time seemed like it might be on the distant horizon. And this is an odd piece of legislation in some respects. It came in on 1st August 24, and it has a number of phased deadlines. So different things have to happen on different days. And the 2nd of February is the date when the prohibitions on unacceptable AI risk come in. So anyone who listened before or who's familiar with the topic will know that the EU AI Act seeks to regulate and in some cases prohibit the use of AI. And that can apply to US corporations as well if they're using AI in their EU operations. So that might be using it on the website, it might be at their facilities, it might be in things like hiring or in relationships with employees. And one of the issues that many businesses have is what you might call shadow AI, that the business itself might say, we don't use much AI. And then you say, well, reach out to colleagues in HR and see if they're using AI. And it turns out they are, or their suppliers are. And particularly in areas like recruitment, areas like talent management, AI has become more and more common. And the obligation on any business that's using AI that impacts the EU is to sort of find out what it is they're using. As I say, that might be developed in-house or it might be bought in AI. It might be AI that suppliers are using on your behalf. And to go through a process to try and identify whether there's any prohibited AI being used, and if so, to try and stop its use or try and somehow legitimize it by changing its use by February 2nd. And the penalties are pretty severe here. If you don't do that, there's a potential fine of 35 million-ish dollars, or 7% of your global annual revenue, whichever is the higher. So if you're a big corporation, obviously 7% of your revenue is going to be a big number. And as I've said, some AI is okay. For most AI, you've got to be transparent. But for many businesses, the first step is identifying the AI they're using. So you've got to reach out to people like procurement to see if you're paying bills for AI applications. Look at HR, and then look at simple consumer AI applications. Somebody in your business is using Grok or OpenAI or Pilot, then make sure that they are being used correctly and legitimately as well. So what's banned AI? That's where it gets, I think, much more complex. And there is a list in the EU AI Act that lists prohibited AI applications. There are things like AI-enabled toys, which I realize most of our businesses won't be providing, but things like social scoring, things like applicants scoring could potentially come within that. Things like CCTV provision, if facial recognition is being used. And again, that might not be something that the business is using consciously, but it might be something that an outsourced security company is using. Maybe that's coming as part of the premises if you've got facilities in Europe. So I think you need to watch out for all of that. As I say, the Act itself is not written in the most helpful language. As an example, one of the prohibited actions is, I quote, the placing on the market, the putting into service, or the use of an AI system that deploys subliminal techniques beyond a person's consciousness, or purposefully manipulative or deceptive techniques with the objective or the effect of materially distorting the behavior of a person or a group of persons by appreciably impairing their ability to make an informed decision, thereby causing them to take a decision that they would not have otherwise taken in a manner that causes or is reasonably likely to cause that person, another person, or group of persons significant harm. So that's just one of the Prohibited Act. There's about 20 in the legislation.
Let me stop you
Uh,
there.
yeah,
Let's explore that.
yeah.
So, does that mean if I'm in a company and I make a strategic or a tactical decision based on information I put into a generative AI, I now have a defense because the AI did it subliminally to me? Or am I liable for still personally liable as I would be if I had made my own decision and acted under a respondeat superior or other theory of corporate liability?
Yeah, I think that's a really good question. And I think the answer is it's the typical lawyer's answer is it depends. The AI Act has elements of personal liability as well as individuals on the corporation. I think the corporation is likely to be the sort of primary target for regulators. And I think in most cases, we're likely to see this being a sort of a corporate prosecution, if you like, or at least regulatory activity. But I think in some cases, individuals may have consequences as well. And that might be under the personal liability provisions of the Act, or that might just be because the employer decides that they were acting beyond their terms of employment and dismisses them and starts an investigation into them, et cetera, et cetera. And there's a lot of complexity on things like that. That's obviously clearly, if we just pick that one, it's clearly pretty wide. So if you prod people to buy your products by retargeting advertising, for example, is that a prohibited act under that section? Because some people are obviously using technology on websites, particularly that are pushing people into a different direction. Some people are doing that with employees, for example. It is alleged that e-commerce businesses, for example, are using monitoring techniques combined with all sorts of different technology to increase performance on people picking from warehouses, et cetera, et cetera. So I don't think it's as simple as saying the Act only applies to pure AI plays. I think that there are complexities for all sorts of different businesses. And I think it's a really interesting question as to where the axe will fall. And I suspect that even rogue employees will have consequences, although in most cases, the corporation will be the one that's fined when the penalties kick in. I think it is a complex situation. And as we said, there's only 2 or 3 weeks to start and do the work. Although I think you can do a sort of simple 5-step plan to try and get into compliance or at least work out how big the elephant is. I think the first thing to do is awareness. So that's got to include your board as well. There's a whole issue that we talked about before as to whether boards are skilled enough to supervise complex areas of technology like this, but it's got to include the board. As I said, got to include procurement, got to include HR, because that's where I've seen most of the shadow AI exist. It's got to be things like an inventory of your AI systems. So what are you using? Can you reach out to employees in the business and get them to confess what they've got? It's got to be an assessment of those AI things. So to look, for example, at whether it is materially distorting behavior for that particular section and doing that assessment across the board. It's got to be things like contracts with AI providers if you brought in solutions, or just with regular providers like HR, like recruitment, where you're saying to people, you will not use AI unless you've told us in advance. And then I think there's a whole transparency piece as well. Again, that will be a defense in some cases. So like the section we just looked at, if it's fully disclosed and the individual's making an informed decision, then that might not be a prohibited act at all. Transparency is going to be a key focus of regulators. And that goes both ways, I think. I think it's being transparent when you are including AI, but also being transparent about AI if you're not using it. For example, I had one client where I said, we're going to have to look at the implications of your use of AI. And they said, we don't use AI at all. And I said, but your website says we use the latest AI techniques available to assess data. They said, yeah, just marketing BS. And so obviously one of the tasks for them is to remove those false promises for the product to head off regulatory difficulties down the line as well. So I think if people follow that 5-step plan, they won't be fully compliant, but they'll be well on the path to compliance. But obviously the sands of time are marching on with that deadline on February 2nd.
I want to take a little bit of a drill down into each one of these points, Jonathan. So let's start
Yeah.
with the board. Now, you work with boards on data breaches, perhaps data privacy. I know you have worked with boards on more general compliance issues. Do you see boards understanding that they have a role in AI, or are we back to 2010 where what is a bribe?
Yeah, candidly, I don't think a lot of boards are set up to be able to understand AI and to supervise AI. And it's obviously something, as you, Tom, I'm involved in a business called Elevate, which is trying to increase the skills of directors, bring new people onto boards who understand technology. That's a real passion of mine. And I think it is an issue. How can you expect a 75-year-old non-exec director who can't switch on his iPad to understand what is a subliminal technique beyond a person's consciousness? This is a really technical piece of legislation. And I think you've got to have a good technical understanding. And I don't think boards can subcontract that to executives within the organization, partly because there's a scarcity of people who understand AI and particularly AI regulation. And obviously, because the board can't just subcontract their oversight, just as they can't subcontract their oversight for their accounts to accountancy professionals, for example. So I think boards do need improving. And I think that's going to be a 2-step process. Boards are going to have to be more open to recruiting people with those skills. And existing board members are going to have to be trained in the complexities of AI regulation. No, you can't just opt out, though. I don't think it's sustainable for any business just to ban AI because they'll lose competitive advantage and they will have shareholders knocking down their doors and asking them why they opted out if that was the best solution. I think we're going to see that in the post office inquiry, for example, in the UK, where opting out of AI just isn't an option either. So I think boards are going to have to improve their skills levels and oversight and understand that AI can be a good thing as well as a bad.
Number 2, AI inventory. Let me even back up further and start with, do you still have clients who don't know what software their employees are using? And could this be an opportunity to actually do an inventory of software that a company has that it may or may not know about, where employees have individually paid for software and then actually been reimbursed?
Mhm.
Or do we say, are you using GPT and leave it there?
Yeah, I think this comes with the awareness piece as well, telling people that you're not prohibiting AI to be the Grinch, but it's because there are valid reasons behind that. No organization is going to truly be able to get to the bottom of this. As an example, I know a colleague of mine said he was sat on a train coming into London and watched an employee with 2 laptops. So what looked to be a personal laptop and what looked to be his work laptop. what is assumed to be the case is that his employer has prohibited the use of AI. So he's got his work laptop where he's obviously got some questions that need answering or a pitch that needs writing or whatever. And he's literally manually typing into an AI application on his personal laptop and then retyping that back into the work laptop using two laptops on the train on his way into work. So even if organizations lock down AI use, that can still happen. People would use their personal devices to ask AI questions. So awareness has got to be a really big piece of this, I think. And I think you're right that there is a whole education piece and there's a technology piece as well. And we've got to make sure that the IS teams, information security teams, are looking out for AI applications. The procurement teams are looking out for AI being purchased through the back door. And yeah, expense claims is a good idea as well to find out if anybody's expensing AI on their corporate credit card.
Number three, assessment of AI tools. And here my question is, how do you assess an AI tool if the tool maker is either the expert or they're just as in the dark as the rest of us?
Yeah, I think again, that's challenging. I think there's an analogy maybe with cookies, where to start off with, it was quite difficult to work out what cookies were doing, but eventually libraries have been built up which will say what a particular cookie is doing. So in most cases, you can get intelligence on what's happening. I think with a lot of AI applications, we're starting to see that as well. Obviously, in most cases, if it's bought in AI, the answer is to ask the vendor and then test the answers that the vendor are giving you. I suspect a lot of people aren't even going through that step of telling vendors that they care about this stuff. And that would at least be a start, wouldn't it? If you ask the vendor to tell you the AI they're using when they recruit on your behalf, for example, so that you can check your comfort level with that. And again, if it's being developed in-house, it's a conversation that you've got to have with the developers to make sure that they're clear about what they're building and why.
Contract review. You've managed to drag in the legal department. So, how do you really talk to the general counsel or the appropriate person that's been appointed to do this? And as an in-house lawyer, I occasionally had an assignment where I was to review sometimes hundreds of contracts. So I know it's a process that can be done, but how would you, number one, ring fence or structure the assignment? And then two, how would you oversee the work?
I think every organization is going to be different, aren't they? But I would have thought for most organizations, the default position has to be comply or explain. In your contracts, you should say, thou shalt not use AI on the assignment that you're doing for us unless you disclose it in advance. Tell us what it is and what it's doing. So explain to us why the service you're providing to us includes AI, and then you can meet your transparency obligations, you can assess it, et cetera, et cetera. I think from a contractual point of view, your sort of default prohibition without explanation is relatively easy to do if you're going to put that into your standard contracting documentation. Now, obviously, there will be occasions when you're going to knowingly procure AI, as I've said, because most businesses won't be able to be competitive without it. And then I think you would go through a process similar to a data protection impact assessment. So you'd look at the potential downsides, the potential regulatory issues, and then you try and address those in the contract as well. Because obviously you can have contractual provisions in place that can be adequate remediation, both under GDPR and under the EU AI Act, if they're meaningful. So I think that's where I would start. Obviously, that's a methodology that different organizations will want to adopt differently, and there are different levels of sophistication. Obviously, large tech businesses have probably got teams of 20 or 30 lawyers dealing with AI on their behalf. For smaller corporations, it might be somebody in the corporate legal department who's keen on technology, might even have to outsource it. But it's a thing that needs to be addressed.
Have you drafted any standard language for such a clause?
I think at this stage, the prohibition piece is relatively easy, if I'm being honest. And we've done terms like that we've inserted into client standard contracts just to say, you will not use AI unless you tell us in advance and tell us what it's doing. So I think that bit is relatively easy. We have had clients procuring AI solutions, and then obviously you've got to do a bit of effort working out what they're doing. But I don't think it's hugely more substantial than the effort that people are taking for data contracts post GDPR, where you're looking at how's the data being processed, where's it being processed, why is it being processed. So I think it's a relatively straightforward task, although obviously with some AI, there's complexity. And I guess the other aspect of complexity here is sometimes the AI is being bought from startup or smaller businesses. So things like indemnities need more attention. What's the point of getting a $35 million indemnity from an organization that's only issued $1,000 worth of shares?
As a special shout out, anyone out there who needs such a clause, I would suggest they contact Mr. Armstrong. But I want to actually say go in a different direction because I did 3 major contract reviews as an in-house lawyer. And if you ever have the opportunity to do one of these projects, don't say no. Run as fast as you can to take it for a couple of reasons. One, everyone will appreciate your work. Two, you will become the in-house subject matter expert that people will call. And literally 20 years after I left the corporation, I still get calls about a contract project I did. The third is the 2 of the major contract projects were around agents and joint ventures. And it was part of, I didn't know at the time, but an FCPA investigation. What I learned from that project was I read 75 joint venture agreements and 215 agents agreements. And so I know the best language for all of those. And that because the language hasn't changed. So if you ever get one of those make work assignments, you think run, take it, and then run with it because it will pay off dividends years later. The next one is transparency. And I'm about to sneeze, so I'm going to put my mic on mute.
You're untied.
False alarm, or not. You spoke a little bit about transparency. I want to maybe include it to, or expand it rather, to include having this plan you've laid out and then going through the steps and moving towards what you or your counselors you're using or the government might think is compliance with this new law. And I say that because at least in the US in the Department of Justice, if you do a risk assessment, they don't expect you to fully manage every risk immediately. They tell you to risk rank your risks and then begin remediation on your top risks and move forward down the list. And it doesn't mean you have to do them all in 1 quarter, all in 1 year, but you have to be showing progress. So I want to maybe pair your thoughts around transparency with having a plan in place that you can show the regulators should they ever come knocking.
Yeah, I think that's a great idea. And I think you're probably going to try and do at least 2 things in parallel. I think you're going to try and be more transparent about your use of AI. One of the other tasks we've done for some clients is alter their privacy policies so that they can at least acknowledge the fact that they are using AI if they are in some limited circumstances. Obviously, as I say, recruitment's the most obvious example. So I think there's that whole sort of general transparency bit. I think if you're going to have, let's say, a job candidate apply for a role with your corporation, and AI is going to be used to select the shortlist of candidates, I think then there's a secondary transparency obligation there to put that up in front of candidates and to say, we are going to use AI to help us select a shortlist. Here's how it works. Maybe there's a demo video that you could ask the vendor to provide. Maybe there's a simple explanation for them there. So that will help with your transparency obligations, not only under the EUA Act, but also under GDPR, also under equivalent legislation in places like Singapore as well. And then I think you're right in terms of compliance is, in some respects, always a journey. And I think in addition, people will be doing a process similar to a privacy impact assessment or a data privacy impact assessment, where they're going to look at what the risks might be in this particular new thing that they're doing, and then look at mitigations. And I think the approach will be similar to that which you've described. I don't think regulators expect you to eliminate all risk. The difference might be with these prohibited AI applications. But if we're talking about more general AI applications, I don't think you're expected to eliminate all risk, but I think you're expected to manage it and to try and deal with that in a proportionate manner. So something like a data protection impact assessment might be a framework to enable you to show that to a regulator and to show the progress that you're making.
Jonathan, we are near the end of our time for this episode, but I wanted to ask you, could you tell our listeners again the name of this act and where they might go so we can link to it in the show notes if they want to actually start doing some work around it?
Yeah, the short name is the EUAI Act. As I say, it came into force in August 24. First provision really is this prohibitions on unacceptable AI, which is in force from 2nd of February. And maybe we'll include a link to our FAQs if that's helpful in the show notes, where people can link through to the actual full heat of the legislation themselves if they want to.
That'd be great. Jonathan, thanks again. I can't wait to see what we come up with for our next episode.
Thank you, Tom.